Of the more than 40 participants at the celebration of the 60 years after the Nuremberg trial celebration that occurred at Chautauqua Institution, September 26 to 29, 2005, was Geoffrey Robertson, who is a United Nations appeal judge for the War Crimes Court in Sierra Leone. He served as its first president, directing the establishment of a tribunal that is now widely recognized as the most effective of the international criminal courts. He is the author of Crimes Against Humanity: The Struggle for Global Justice. Since 1985, Mr. Robinson has been Commonwealth Counsel for Dow Jones, Inc., has defended journalists and editors of the Wall Street Journal, Barron's, and Far Eastern Economic Review in many foreign courts. He's represented Jonathan Randall of the Washington Post, and he also represented Salman Rushdie in the Satanic Verses case. Mr. Robertson currently sits as a recorder in London. He is the head of the Doty Street Chambers, a master of the Middle Temple, and visiting professor in human rights law at London University. An extraordinary resume, and here are his comments at the conference.
Last year, the United States engaged him to conduct the initial training for the Iraqi judges who will try Saddam Hussein. Judge Robertson.
Thank you very much. It's a great honor to be invited to reflect on Robert Jackson's legacy 60 years on. It was on the day that Roosevelt died that Robert Jackson was addressing the Society of International Law, and he told them that it would be better to shoot the Nazi leaders out of hand than to destroy belief in the judicial process by conducting farcical trials. And that approach has always seemed to me to be Jackson's greatest legacy, proving to the sentient world that the legal process could rise to the challenge of judging both fairly and effectively men who had been not only defeated but demonized. To do so, he had to struggle mightily to overcome two arguments. First, the argument put most forcibly by Winston Churchill that the legal system was not equipped to deal with political crimes of this heinousness. He then had to overcome the other argument coming particularly from the Russian delegates who wanted a show trial in which guilt and indeed sentence would be preordained. To the extent that he succeeded, we principally owe the legacy of Nuremberg, the legacy we're trying to deliver on today, not only in the safety and civility of The Hague, but in war-torn Baghdad, in malaria-ridden Sierra Leone, in East Timor, and shortly in Phnom Penh. We're trying to achieve delivery on that legacy in very different circumstances, so much so that we've had to adapt it considerably. But in doing so, we must carry with us Jackson's principle, the principle of which he was always so conscious, that if our trials cannot be fair, they should not be trials at all. The stark alternative to justice is the diktat of the firing squad, applied through treaties that, and we must always remember the second great achievement of Nuremberg, which is often not mentioned or not realized, is that the great human rights triptych that emerged in 1948, beginning with the Genocide Convention, the United Nations Declaration of Human Rights, and then a few months later the 4 Geneva Conventions, were all influenced in their drafting, influenced the mindset of the people who drafted them by transcripts that they were receiving of the evidence at Nuremberg, the evidence that Jackson and his colleagues had put together. So the whole human rights edifice that is now so well known, it's not perhaps as well known just how influenced it was by the evidence at Nuremberg. And thirdly, just to pick in a different dimension the legacy, it is that of remembering the Holocaust, because the Holocaust is now utterly central to the European imagination. And the awful truth, of course, is that it means to us today much more than it meant at the time it was being perpetrated. There's a brilliant article by Tony Judt in this current New York Review of Books explaining just how, when the concentration camps were waxing, the Allies knew about it. They didn't bomb the railway tracks. The German people knew about it. 23,000 of them were employed as guards. The Vatican knew about it and said nothing. It was not, at the time it was going on, it was not the appalling event and the central event of European memory that it is today. Nuremberg and Jackson's evidence, the fact that there was an adversary trial which enabled that evidence to be assessed and to be adopted, ensured that after such knowledge there could be no forgiveness. So this contribution to law, contribution to human rights, contribution to history and remembering by Jackson and his colleagues back in what they did in 1945 is astonishing, and this conference has paid tribute to it in different ways. Today I want to put it in a little context to show how radical the idea of putting on trial leaders who mass murder their own people was in 1945, and to say a few words about some of the problems that we face in delivering on that legacy in very different circumstances today. Modern international law began, all scholars agree, with the Treaty of Westphalia back in 1648, a treaty that ended the 30 years of war on the continent, a treaty that enshrined the right of the prince, of the leader, to do anything he liked to his own people. International law, Westphalian international law, was set up on the basis, on the Machiavellian basis, that it applied only to states, that one state or collection of states could never call the leader of another state to account for what they did to their own people. They would be above the law. Well, the great thing about the Treaty of Westphalia was that England wasn't part of it, nor was America, which was, of course, governed by England. The American Puritans, some 30,000 of them, were by this stage in Massachusetts. A few months after the Treaty of Westphalia, the English Parliament, yours and mine, sent a brief down to the Temple where the barristers were, to its Solicitor General, a man named John Cook, and that brief instructed him to prosecute the first, the head of state, Charles I, for war crimes, to ensure that there should in henceforth be no impunity. The word impunity comes into our language in the brief of Parliament in January 1649 to end impunity. Impunity in the sense that Kofi Annan now uses it, of the freedom that tyrants should never have to live happily ever after their tyranny. That extraordinary event was produced not only by English, but by the Puritans who'd come back from Massachusetts, men like Hugh Peters, the founder of Harvard, Henry Vane, one of the first governors of Massachusetts. The Harvard graduating class, 7 out of 10 of the first Harvard graduates became colonels and judges of the king, who was charged with the crime of tyranny. The Solicitor General, Jackson's, I suppose, distant predecessor, invented the crime of tyranny to charge a man who had not only started a war that killed 1 in 10 Englishmen, but had supervised the torture of prisoners of war, had commanded pillage and plunder, war crimes of the time, who had abolished Parliament for many years and who had sought absolute power. Well, he was brought before his judges, and of course he had the purest form of sovereign immunity because he was the sovereign. And he said, in words that are identical in translation to those that Saddam Hussein used when he was brought forth to face his judge. He said, "By what authority do you try me? Legal, I mean. By what authority do you try me?" he said to the court, and he refused to acknowledge it. He was given plenty of opportunities, but he refused to plead because he claimed that the court to try him was unlawful, and he maintained that position so that the evidence of his torture, the evidence of his war crimes, could not be called. In those days, a refusal to plead amounted to a confession, and he had to be convicted, and he was executed. He became, by that execution, something of a martyr, and 11 years later, after the Republic had foundered and his son came back, the judges of Charles I were taken out to the Old Bailey and were convicted and were hung, drawn, and quartered, disemboweled in the presence of Charles II. It was not a good beginning for putting heads of state on trial. And it's remarkable to read the prosecutor in 1660 at the Old Bailey, who said these men, people like Peters and Vane and Cook, were part of an American religious conspiracy. These were terrorists hatched in Massachusetts by the Puritan preachers who persuaded them to come back and to convince Cromwell to cut off the king's head. Well, the first 10 were disemboweled, and the public, they were so brave in going to their deaths that the public sympathy started to swing behind them. There were all these Republicans that they couldn't, the king decided he couldn't bring to trial, but he couldn't, of course, leave them in prison indefinitely because of habeas corpus. So his legal advisor, a very smart man, had an idea. He said, "I know what we'll do. We'll put them on offshore islands where habeas corpus doesn't run." And that was the precedent for Guantanamo Bay. And it was seen as devious even in those days, because in 1679 we passed the Habeas Corpus Act, which applied habeas corpus to offshore islands, Jersey and Plymouth and so on, where all the Republicans had been sent. And Justice Stevens, in his decision in Russell and Bush last year, which ensured due process for the Guantanamo Bay detainees, referred to it and applied it on the basis that it was still law. So there was the first attempt back 300 years before Nuremberg with its grisly end. That affected Britain very much, and when Napoleon was defeated and was declared a war criminal, there was no question of putting Napoleon on trial. He was declared an outlaw, and he was spent the rest of his life simply by political decision, supported by his own country by that stage, of exile in the little island of St. Helena in the South Atlantic. There was no international law, even at the time of Versailles in the First World War. The 19th century produced no international law. There were meetings in Petersburg and at The Hague that limited the new weapons like dum-dum bullets. There were there was a kind of international agreement about slavery. There was, in fact, an agreement for an international court. The first international criminal court was agreed upon in 1821, which would sit in Freetown in Sierra Leone with an American, a British, and a Spanish judge to decide or to approve the interception of slave ships. The Americans pulled out plus or change, one may think, as we go forward to the International Criminal Court. But by the time of Versailles and the First World War, with all the carnage, there was, for the first time, a real decision by the British to bring the Kaiser to trial for unrestricted submarine warfare and the aggression and the invasion of Belgium. But the Westphalian notion that it was not for a collection of states to put heads of states on trial was insisted upon by Woodrow Wilson and his Secretary of State Lansing. They said that the sovereign immunity must remain. Westphalian immunity was absolute, and the Kaiser, although the British wanted to hang the Kaiser, the Kaiser was allowed to slip away to Holland and remain unhung until his death in 1941. The only trials that went on were at Leipzig, where those who'd been accused of war crimes in the First World War, gunning down mariners after sinking their ships and so forth by German submarine commanders, were put on trial. And if you want an account of losers' justice as compared with victors' justice, just look at the Leipzig trials, where of 800 tried, 790 were acquitted, and the 10 who were convicted were allowed to escape from prison within a few months. So one wonders what would have happened if the Kaiser had been put on trial, whether 20th century history would have been quite the same. Certainly the fact that the Kaiser was not on trial played very much on Goering's mind in his interviews with Gudensson in Nuremberg. But there it was, the opportunity was lost after the First World War. And indeed, we come into the Second World War with no clear conception of what should happen to the Nazi leaders. There was a very important development, I think, because human rights as a concept had never been mentioned in the, it had always been natural rights initially, but there was no concept of enforceable human rights. We get Roosevelt's great speech for freedom speech, which was influenced by H.G. Wells and his little group who had put together in 1939 the first blueprint for a kind of enforceable international criminal law. They were a group of English middle-class writers mainly. Wells and J.B. Priestley and A.A. Milne would motor up from Pooh Corner to join in the drafting committees. But there was no... when the war turned, and when in 1944 the first discussions about what should happen to the Nazi leaders started, we had a complete split between, on the one hand, Churchill's view that simply the top 75 Nazi leaders should be given 6 hours after their arrest to say their prayers and should then be shot by firing squad. In fact, the Lord Chancellor, Simon, went round the Houses of Parliament saying, they want to put Hitler on trial, the Americans want to put Hitler on trial, as if there could be simply no question of a trial because he was so manifestly guilty. But Churchill was not, was a very deep thinker about these matters, and his arguments mustn't be put aside. He was a great fan of Cromwell's. He'd studied the trial of Charles I. He thought that the trial by Charles, using the trial as a soapbox to condemn the court, by the execution which made him a martyr, he was very concerned that Hitler would use the dock as a soapbox, rather as one might see Churchill's argument having some force in relation to Milosevic today. So that was the reason why the British were so hostile to the concept that Stimson, I think, was the first, to give him his due, to promote of a trial for the Nazi leaders. The statement of position, the American position against the British position, was authored by Jackson and endorsed by Truman. That left a complete deadlock, and the casting vote went to Joe Stalin, who loved show trials so long as everyone got shot at the end. And he cast his vote with Truman, and that is how Nuremberg came to pass. Ironically, thanks to Stalin, we got Nuremberg. It was remarkable at the London conference, I think, when the Russians certainly came with the idea that they would have a Stalin-esque show trial, and there's a wonderful recording towards the end of this discussion by one of the Russian judges. He says, "What is this cross-examination?" He really couldn't understand that what was envisaged was the possibility of disputing the evidence called by the prosecution. Well, why did Nuremberg succeed? Why is it not properly described as victor's justice, but as victory giving an opportunity to do justice to the authors of the Holocaust. Jackson himself said he owed his success to, I quote, I think, the Teutonic habit of writing everything down. They had the evidence, they had the signatures on night and fog decrees, they had the whole access to the bureaucracy. That's something we don't have in places like Sierra Leone, where there was another reason why Nuremberg succeeded and why our current trials are not always succeeding, and I think it's very important. The defendants cooperated. They didn't play the King Charles gambit. They didn't refuse to acknowledge the courts. That was Goering's first position, and he called the co-defendants together in prison a couple of months after they were there, before the trials had started, and said, look, we're going to say 3 words to these judges, and he quoted from one of Goethe's warrior heroes, loosely translated as kiss my ass. And that was all they were going to say to the court. But as time went by, they got sucked in to the fairness of the proceedings, which were totally unlike any Nazi proceedings, legal proceedings. And they decided to play the justice game, or at least Goering did. Others cut deals. There was a sense that they distrusted each other. Some of them they knew were going to support the prosecution. So, for one reason or another, they used the trial to make their excuses to posterity in ways that modern defendants don't do. Many defendants in war crimes courts see the court as an extension of the war, and they're out to discredit, destroy, and disrespect it in every possible way. If you just look at those pictures, I was watching the other day Goering getting up to make his opening speech, and he's called up and getting up to plead, and he treads on everyone's toes as he gets to the center, and he's got his pieces of paper, and the judge, Geoffrey Robertson, says, no, you're not making an opening speech, just say guilty or not guilty. And he says politely, not guilty, and goes back. That cooperation with the court sometimes doesn't happen today, and that's one of the problems we have to face in working out how to do justice to men who want to derail the entire proceedings. But I think that element of cooperation, they played the justice game, that enabled the adversary system to work. The adversary system breaks down with defendants who don't come to court, with defendants who scream abuse at the judges, with defendants like Milosevic, who hold it to ransom. I mean, Nuremberg took 10 months. Milosevic's trial and appeal are going to take 10 years because of the way he's playing it with his self-induced illness, forcing the court to... I mean, the prosecution took 3 years. The defense will take another couple of years, then the whole thing will be reheard by the appeal. And it's just... And this gets back to the question of, do you impose counsel on defendants who sack them all the time in order to create havoc? The problems we face today are a long way from Nuremberg, because, remember, that central fact, the trial worked because the defendants cooperated. It worked, I don't think fairly, but I think fairishly. The treatment of the German lawyers was regrettable. They were excluded. The prosecution and the judges fraternized very closely. The Germans were generally second or third-rate lawyers who were very often faced reprisals from their own bars for even defending the Nazis. The British would not allow QCs to defend Krupp. There were no American lawyers and British lawyers for the defense. There was no right of appeal. There was no full prosecution disclosure. Jackson is criticized today for not disclosing to the defense the secret codicil of the Soviet German agreement that where they'd agreed to divide up Poland, which would have blown the conspiracy charge out of the water, but he must have been under enormous pressure not to disclose it. But I think when making criticisms of these aspects of the Nuremberg proceedings, we must remember that due process has moved on a long way from 1945, and that all things considered, the trial was fair according to the standards of 1945. And so the world moved on. We moved on thanks to the evidence at Nuremberg. And the great thing about Nuremberg is, one of the many great things, is that the judgment confounded Holocaust deniers ever after. And so that it did that. And the evidence produced the human rights triptych. And for 50 years, the Nuremberg legacy was just put in cold storage because of the Cold War. There was, we had the good conventions, didn't we? We had conventions against racism, conventions against torture, and against mistreating women and children. But they never had enforcement mechanisms attached. There was never any process by which those who destroyed them could be put on trial. And as someone said, surveying the killing fields of Rwanda, 50 years later, the road to hell is paved with good conventions. And I remember hearing a joke when I was in Sarajevo in 1994, what do you do to a man who kills another man? You put him in prison for life. What do you do to a man who kills 20 other people? You put them in a mental asylum until they're cured. What do you do to someone who kills 200,000 people? Oh, you send them to a luxury hotel in Geneva for peace negotiations. And that was told of Milosevic as a black joke, and it got blacker and blacker. But thanks to initially the ICTY&R, to the Rome Conference, in which 120 nations pledged their support for the ICC, to the courts, to the hybrid courts in Sierra Leone and Cambodia, to the Queen East Timor, and now in Baghdad, there is a sense that at long last, Jackson's legacy is being collected upon. But there are problems, and I'll briefly mention a few of the most difficult. The problem of cost and delay. At Nuremberg took 10 months from beginning to end. Trials are taking, on average, in The Hague, the ICTY, 47 months in prison before they come to trial, and trials are taking a very long time. One reason for this is the tendency of prosecutors to overload the indictment, and I think Nuremberg has become a misleading legacy in this sense, that they think that the courts should, at the end of the day, be able to produce a kind of judgment at Nuremberg which confounds, which writes history. I don't know that our modern courts can write history. I think their job is to decide on the evidence whether the defendant is guilty or not. And I agree very much with Dave Crane that while this is the role of truth commissions, let's allow the truth commissions to write history and get on with convicting or acquitting people within a reasonable time. If you want to write history, it will take years and years, and the cost will be considerable. The second principle, we've taken the adversary trial process and some of the concepts in England and America to extraordinary degrees with the defense. We've had a lot of problem with defense lawyers, and corruption has inevitably set in because we, first of all, allowed counsel of choice principle. And so at Arusha in particular, the ICTR, counsel ambulance chase would persuade defendants that they could, because of the enormous money, comparatively enormous fees that were being paid, they would fee split. They would give the family half of the money that the defense would claim from the United Nations. And so you had the scandal of men on trial for genocide, $1 million spent on their defense, appearing in Armani suits in their dock, their families driving around with Mercedes through fee-splitting deals with lawyers. That kind of problem, and the problem of very bad defenders persuading defendants to bring them in, certainly led us in Sierra Leone to set up the principal defender system, the defense office, to try and make the defense side of the court to have a quality control so that only expert defenders were permitted, but to put the defender, the principal defender, up as a foil to the prosecutor, because the problem with Nuremberg and with subsequent courts, and even the problem with the ICC, is the prosecutor has this enormously important position alongside the judges and the registrar, and there is no defence capacity there to, as it were, counterbalance him. So it is very important to look at a quality control on defence lawyers to ensure that they're good, and secondly, to give the defence a real basis in the court and to act as a counterbalance for the trial, for the adversary system to work properly. The third problem, of course, as I've indicated, is that many defendants in many of these courts are playing the King Charles gambit, are refusing to recognise the jurisdiction of the court, and are adopting tactics that, to a greater or lesser extent, are disruptive. And some courts have even brought down rules that those who are charged to, who are contracted to defend, are not allowed to be dismissed by their clients. They've got to stay and represent their clients no matter what clash, no matter whether the client wants them or not. They're ordered to stay and to defend him. And this, of course, is inconceivable in a national system. But remember, in a national system, clients look to their lawyers to play the game and hopefully to beat the system, to get them off on a technicality, and they show respect for the court and for the adversary process. It's very different in a war crimes court, where the defendants, very often part of groups or armies, see their best way of proceeding is to disrupt and to discredit the court itself. So there is a growing feeling among judges, and it's got to be faced and dealt with, that we should move to an inquisitorial system, the European system, that Jackson rejected, other than its not having a jury, that we should move to a different and more a system under which a judge investigates the prosecution evidence, prepares a report, guilt or innocence, and then you have a trial proceeding in which the investigating judge presents the case, and at that point only can the defendant challenge it. So it means the defendant does not have various rights that he has under the Anglo-American trial process. My view is that, I'm coming round to the view, that where defendants refuse to recognize the court and where they actively disrupt the court by hiring and firing teams of counsel and so forth, then they may have to face, then the court may have to shift to an inquisitorial mode, because the problems caused by disruption are so great that we can't deal with them effectively. We have to retain, as Jackson said, at all times a sense of fairness, but it may be that a different mode of trial is appropriate for those who refuse to respect the court. There are other problems. Dave Crane mentioned some of them. The diplomats still suspect and want to do not approve of justice processes which deprive them of powers to do deals, to give amnesties, to enable them to negotiate with tyrants rather than without the prospect that the tyrant will be put on trial. I've mentioned the US administration's opposition to the ICC. That was really debilitating last year. I think in March of this year we saw a change when the US at the United Nations allowed the genocide allegedly in Darfur to be referred to the ICC. I hope that presages a time when the US can full-bloodedly support Jackson's legacy and see that an international criminal court is a help rather than a hindrance, and offers no threat, conceivable threat, because it's a court of last resort. It only applies to states where there is no effective prosecuting authority. I can't see on that basis that it could ever apply to American soldiers in a military where any conduct that could conceivably be brought before an international criminal court would be punished, as Ms. England was punished yesterday. But there remains, and here I'll end, a great debate, the unfinished debate over the death penalty. In 1945, hardly any countries had abolished the death penalty, and hanging in front of the Allied press seemed to be the logical conclusion of the Nuremberg trial. And indeed, I think the bodies were cremated, weren't they, at Dachau? And they were thrown in some fast-flowing river for fear that they'd otherwise become a shrine. And this macabre process, as we think, many of us think it to be, is no longer possible in an international law climate which disfavours the death penalty to such an extent that all international courts are prohibited from passing it. And there is a great debate at the moment. You don't see it in the press, but I know it's going on because I know some of the people involved, between the English and the American allies over, been going on for a while, over Saddam's trial, where it would seem that the American position is, yes, we would like to see Saddam hung in a square, in a dusty square, with Shia people screaming their approval as he swings in the wind, and the British saying, well, not only is that barbaric, the state can't teach reverence for life when it takes it, but it's also likely to make him a martyr, to inflame the already inflammable civil war. See Charles I and the fate of the Republicans. So that debate is going on, but Mike Newton, who's made such a valuable contribution to this conference and to the general principle, wrote a piece last year in the International Herald Tribune, and he threw down the gauntlet. He said, of course, what really has armchair lawyers riled up is that Iraqi authorities have decided that those convicted of the greatest offences can be sentenced to death, just as at Nuremberg the death penalty is available in Iraq because no one can figure out what other punishment fits such a crime. Well, that's a challenge, and one can only answer it by figuring something out, because I think you cannot have Saddam in prison in Iraq forever. You cannot have I would have thought, some of the people in Sierra Leone there, or Milosevic, there to create and the same kind of problems. Saddam and his henchmen simply can't be imprisoned there, but they could go to a cell in Finland where Milosevic is destined if he's convicted and where the ICTY defendants are going. But that country, of course, has the most liberal prison regime in the world, and the victims are starting to complain. They say, look, there are these people sentenced to 50 years for killing 7,000 Muslims at Srebrenica. They've got phone calls, they can have family visits, they can watch cable TV, 140 channels, most of them showing pornography. They're not being punished, and one could send them to Guantanamo Bay, but that's too tropical and comes with far too much baggage. I've quite seriously asked the UK government to make St. Helena available again. And even better, the Falkland Islands for fallen dictators, and there Saddam and Slobbo, if convicted, could spend the rest of their life communing with the penguins. The crimes alleged against them are unforgivable, and they remain dangerous in their own countries. And it seems to me entirely proper to impose that a prison regime of that severity in exile on men as an alternative to hanging. So at the end of the day, I think we must salute Nuremberg as a momentous and almost miraculous precedent, and salute its jurisprudential legacy for establishing that there can be no impunity and no sovereign immunity for a certain class of crime that is so heinous, so we call it a crime against humanity, because we are all, the very fact that fellow humans can perpetuate, can conceive it, and commit it, lowers us all, wherever we are, as human beings. whatever our nationality or ethnicity, were lowered by these particular crimes. But in collecting on Jackson's legacy, we must remember his overwhelming principle that you can't have trials at all if they can't conform to basic standards of fairness. We must remember that circumstances have changed so much from occupied Nuremberg, and today that higher standards of due process give war crimes defendants the opportunities to disrespect the courts in ways that simply were not open or were not chosen by Goering and his co-defendants. So, although we face problems in trying them fairly and effectively, and by effectively I include cost-effectively, I've got to go to the United Nations tomorrow to the donors who pledged money to keep the money coming in for the court. That was never a problem that judges at Nuremberg had to face. But we've got to remember that the exigencies of today require us, in some cases, to raise money for our own courts. But it helps to refresh ourselves by returning to the foundations laid by Robert Jackson and his team 60 years ago, and I thank you very much for the privilege of being able to do so.
Have any of the defendants, and so forth, used the refusal of the United States to sign the Treaty of Rome as a defense argument against the legitimacy of the system?
Yeah. Oh, yes. Defense counsel will use anything that it sounds in argument, and that certainly has been built in to one of the arguments. I mean, we are at this very rudimentary stage. I mean, there was that 50-year gap, but for heaven's sake, I think the essential thing is that we are still at a very early stage. I think our grandchildren I hope our grandchildren will be appalled that we allowed Idi Amin to die in his bed. We allowed Pol Pot to live happily ever after. We are at an early stage in collecting on this legacy, and we are still. I mean, we had a great debate. I was one of the judges who came to the first, had to decide whether the conscription of children to be soldiers was against international criminal law. Of course, it was never an issue that was raised at Nuremberg. But in deciding whether a particular appalling kind of action achieves the heinousness threshold, if you like, of a crime against humanity, you've got to look. I mean, I'm in a sense a legal positivist in that I differed from my colleagues who thought it was so terrible it had to be a crime against humanity. It was wrong in principle. But I dissented from their view that it was a crime in 1996 when the allegation was laid. I said it didn't become a crime until at least the Rome Statute, where 120 nations subscribed to it. So and then of course the argument is, oh, but America didn't support the Rome Statute. And so, yes, in every case where we are considering whether a crime, a particular heinous conduct has crystallized as a crime in international law, America's position will obviously be referred to.
Do you consider any of the positions, the problems cited by the American government, as legitimate in objection to the treaty?
Well, I can see a lot of force in the criticisms that have come, that the American government has made from time to time of the delay, of the cost, and so forth. But they are criticisms that can be practical criticisms that I think can be overcome by better standards, by experience, by lessons learned, and so forth. I don't see the force of the basic criticism, which is that an American may end up in the ICC, because the ICC, if you look at it, is a court of last resort that can only indict anyone either because the Security Council directs that and the Security Council, America has a veto in the Security Council, or where the government of the state or the military have not taken action. And as I say, I can't envisage that any American soldier who behaved in a way that would qualify for indictment would not be proceeded against by the military or by the courts here. It's just inconceivable to me that an American soldier would ever end up, unless he was or she was a soldier who had, was fighting for some Taliban-like force. So I don't think that the fear that you're going to get an American indicted is a realistic one. Yeah.
What do you see as the, I mean, you know, given the U.S. reticence to the ICC, they've showed a renewed enthusiasm for ad hoc tribunals, precisely because they can keep them on a shorter leash.
Yeah.
What do you see as the strengths and weaknesses of an ad hoc approach to international criminal justice?
Well, it's a beginning, isn't it? It's a start. I've been very grateful for American support in Sierra Leone. It's a court where one of the three major funders, it's the Netherlands, Britain, and America, are enabling us to try to end impunity in Africa, and that's very valuable. It's just, and it's interesting that with Darfur, which is just over the border, so to speak, it may be our court when we finish that the ICC will end up prosecuting because it's the best court and has the best facilities in the area. So I think that it's regrettable that America won't sign up to international criminal justice in full-blooded principle as 99 other states. I mean, 99 countries in the world have ratified that treaty, and which is an amazing development, I think, and ratified it far more quickly than anyone could have suspected. So but the American support in the short term for ad hoc courts is likely to be the way to go. But I think the cost, well, it comes back, if you like, to pragmatic considerations. Yes, you can set up an ad hoc court for Darfur. You could set up an ad hoc court for the Congo. You could set up an ad hoc court for the Lord's Resistance Army in Uganda. But it becomes much more cost-effective to use the ICC. So I think that the best argument against ad hocery is really that everything is there. You've got, the great thing about the ICC is that you have trained judges and trained prosecutors. I mean, we have great problems with international judges, particularly those that are put up by states. Sometimes it's said to get rid of them because they're an embarrassment. They have, I won't go on, but we have problems with international judges, but not with the ICC. They were elected, and after a pretty thorough election from, and they're there ready and waiting. Why go through the cost of setting up something ad hoc when you can have a system, something that's already working?
Thank you.